Welcome to the Probate Nation, especially you viewers from the great state of Wyoming, also known as the Cowboy State, where cattle outnumber humans by 2 to 1. My name is Richard Ruddy. Tonight you will learn the basics of probating a Wyoming estate, from where to begin your probate journey, the legal and tax stops you will need to make along the way, and when to deliver the estate to the beneficiaries. Probate is very much like traveling on a slow-moving steam engine train, which calls to mind the train trip many years ago of a famous U.S. Supreme Court Justice, Oliver Wendell Holmes. When approached by the conductor confirming passenger tickets, Justice Holmes could not find his ticket. Conductor recognized who he was and said that would not be a problem. But Justice Holmes dissented, as some judges are apt to do. While he had purchased a ticket, he needed to know where he was going. We are fortunate to have with us tonight Marty Oblasser, a Wyoming probate attorney who knows all about Wyoming probate. But first, let me tell you a little bit about Marty. Marty Oblasser is the managing partner of Wyoming's oldest law firm, Corthell & King Law Offices. Her practice focuses on estate planning, asset protection, and business creation. She recently authored Wyoming legislation concerning asset protection and served as the project manager for Wyoming Supreme Court when it created a newly formed Chancery Court. She has been a presenter at programs held by Wealth Council, National Business Institute, Southern California Institute, as well as other organizations. So we're pleased to have Marty join us tonight. Marty, before we jump into this topic about Wyoming probate, with all these YouTube videos out there on just about every topic imaginable, so many people like to do things themselves these days. Is a Wyoming probate something they can do on their own, pro se, without an attorney?
Great question. No, unfortunately not. So pro se is when somebody's allowed to represent themselves in court and handle their case on their own. And the way the Wyoming courts look at it is that the personal representative is administering a decedent's estate, and therefore it's not their own case. Therefore, they cannot handle it pro se, and they do in fact need to hire an attorney to help guide them through that process.
Okay, well that's good to know, and I think it's important for folks to know at the outset, the information we're going to give tonight is not going to empower them to probate their own estate or an estate for a relative. Let's take a look at a basic introduction. What court oversees Wyoming probates?
Well, we are a very small state, as you mentioned in the beginning, and so we have a court of general jurisdiction, which is the Wyoming District Court. That is the court of record that handles all of the probate cases. It's not assigned to any specific judge. It's handled in the county where the decedent passes away or where they own assets. It is important to note that Wyoming has created a new court called the Chancery Court to handle various trust administration and business matters. And if the Chancery Court is handling a matter where the probate estate is ancillary to the main matter, then the Chancery Court could have jurisdiction over that probate as well.
So you mentioned, so once the probate's initiated, we'll get into the details about how we initiate that. Once it's initiated, is one judge assigned to handle that particular probate, or does it get rotated around depending on the day and the hearing and so on?
Correct. One judge is assigned to handle the probate matter from the beginning to the end. And if the personal administrator or the personal representative is not a Wyoming resident, they need to obtain a Wyoming resident to help them with that process. And the attorney for them can also serve in that capacity. But one judge will handle the probate process from beginning to end.
Okay, so from a big picture standpoint then too, I understand from our discussion in preparing for this show that there are a couple of options to handle probate in Wyoming. So just those two options are, what are those two options?
Correct. We have a small estate process and a formal estate process. And sometimes it's called a summary procedure or informal probate and a formal probate. And
does the existence of whether or not the decedent had a will or didn't have a will make any difference as far as which probate we would use? Which probate process?
No, that doesn't matter in Wyoming.
And the other thing, I guess, which I want to bring up at the beginning here, which we talked about as we sort of transitioned from your introduction, are there a lot of forms available online? Are there checklist about things so that someone could actually undertake, even though the court won't let them do that, to undertake to probate an estate? Is there anything out there like that, or do they have to go see a lawyer?
Well, when you asked me that question, I actually decided to do a little research to see if I could find any forms. And still, as of last week, currently there are no forms online for somebody to initiate or help facilitate any of this probate process themselves. I will say that if it is a short form probate and there is no real estate, and I know we'll get into that in a moment, I have heard of times where the county clerk will have a form that somebody can fill in, but that's on a county by county basis, whether or not they'll provide that form to the person who needs to administer that short form probate without real estate.
Yeah, my experience has been that the clerks in many of the jurisdictions are reluctant to do that because they fear they're giving legal advice, which they're typically prohibited from doing by statute. So let's just go ahead and talk about probate with a will. So where do folks typically keep their will, folks in Wyoming?
In Wyoming, we normally see that they'll keep it at home in a filing cabinet or a safe. Oftentimes in Wyoming, it's a gun safe. Sometimes we see that they'll keep it in the bank safe deposit box. We see that some attorneys will keep a will for their clients. I will not. Those are generally where they're kept.
Yeah, the will banks are something that I think for many lawyers is discouraged because people move and next thing you know you're stuck with all these wills you can't find people for. But if it's in a commercial safety deposit box at their local bank, how do we go about obtaining that will out of the safety deposit box in Wyoming?
Yeah, so this will really depend on where the safe deposit box is located, which institution. Banks often require different things to allow somebody access to that safe deposit box because they're always worried about liability. Generally, what they see is that they will require the personal representative to obtain an order from the court allowing them access to the safe deposit box. So now the personal representative needs to take another step. If it's not a contested probate, then it usually takes about 20 days to get a court order allowing them access to that safe deposit box.
Okay, so let's talk about the types of wills that can be admitted to probate. So in Virginia, we generally want to have two witnesses and we like to have a self-proving affidavit and those types of stuff. But in Wyoming, tell me a little bit about what type of wills will be admitted to probate in Wyoming.
Sure. So it sounds like Wyoming may be similar to Virginia. We also, when somebody creates their will, there's a couple different ways they can do it. First, if it's all in their own handwriting, they don't need any witnesses. It's called a holographic will, and that is completely valid in Wyoming. What we often see is the wife will write out the will for her husband to sign because the husband just doesn't want to do it, and he signs it. And that is not a holographic will because it's in his wife's handwriting. Hers is valid, his is not. Then if it's not in your own handwriting, then Wyoming says you need two disinterested witnesses to sign saying that they've seen you execute your will and they cannot inherit under the will, which is what makes them uninterested. And it can also have a self-proving affidavit stating who the disinterested parties were, there was a notary present, that it was all done properly, and that can be admitted to probate as well.
Now, I know here in Virginia we have a requirement to turn over wills within a certain period of time, and I gather from our discussion that Wyoming has a similar requirement. We seldom see anybody try to enforce that. Is that true in Wyoming?
Correct. So our statute says that once you learn of somebody's passing, you need to deposit their will with the court within 10 days, but that's rarely enforced, and I've seen it go 15 years.
Now, let's flip the page. Someone does not write their own will, or they write it incorrectly because wife fills it out and husband signs it so it doesn't work. So now we're into a probate without a will. If there is no will, what are the laws that govern how the property is distributed?
Sure. So if somebody hasn't properly created their own will, then the Wyoming legislature has taken it upon themselves to say where their assets are going to go. And that's called intestate succession. And that's who receives the assets when somebody passes away without a valid will.
And so tell me a little bit about how those rules, in other words, what's the priority for distribution when it goes by intestate succession?
Sure. So the legislature has decided the best way for your assets to go in the event you don't direct it or you don't direct it properly in Wyoming. And what they've decided is if you have a spouse and no kids, it will 100% go to your spouse. If you have kids and no spouse, it will be divided equally between your kids. What's really interesting and tricky is when you have a spouse and kids, because what many people don't realize is now the surviving spouse is owning the house one half themselves and one half with their children, which they didn't expect. And then if there are no spouses or children, the legislature has said it will go to your parents and your siblings and continue to follow the bloodline.
Sure, and that's I actually have gone down pretty far. It can get very complicated. So if the process to probate an estate with no will is very similar, our options are the same with when there's no will. Is that correct?
Yes, that is correct.
Okay, so let's talk about probating small estates or not having to probate. So, please explain what estates qualify for a probate under this summary procedure that you were discussing earlier.
Sure. Currently in Wyoming, they have set a $200,000 threshold to value your assets to decide whether or not we can do a small summary procedure probate or whether we need to go through a formal probate. And that doesn't matter whether or not we have real estate. So if somebody has assets that are under the value of $200,000, we can handle it with a summary procedure. If the value of their assets is over $200,000, we're automatically in a formal probate procedure.
And if there's no real estate, so there's no filing with the court, so what do we record at that point in order to show the transfer of assets?
Sure. So if we are doing a summary procedure for a small probate and it does not have real estate, we can just record an affidavit of collection and distribution with the county clerk where decedent passed away or they own assets.
Very good. Now, if there happens to be real estate involved, then what has to be filed in that circumstance?
So it's still a short form small probate, but we actually do have to file with the court an application for decree of distribution in order to transfer that real estate.
Okay, and what does that person get some sort of evidence of authority to act back from the court?
This is actually a problem with Wyoming short form probates that include real estate because they don't get letters of administration. They don't have any documents showing they have authority to act, which becomes problematic when dealing with financial institutions.
Okay, well, let's switch gears to what I think is probably more typical, which is the formal probate. Okay, so
yes.
Please explain what estates take advantage of the formal probate or have to take advantage of formal probate.
Sure. So we know that if the value of the estate exceeds the limit, that $200,000 threshold, we have to utilize that formal probate procedure. Also, if we see that there are going to be creditor issues, there's very clear ways to cut off creditor claims in a formal probate situation. So we might utilize a formal probate then, or if the will is going to be contested or if there's going to be issues with other family members, we might utilize a formal probate.
And so if I'm going to start a formal probate, what documents do I file with your court?
So if there's a will, we file a petition asking the court to admit the will to probate and appoint the personal representative. If there's no will, then we just ask the court to appoint a personal representative and start the probate process with the same petition.
And is there a publication requirement when you petition the court for a formal probate?
Yes, so we have to send all of the heirs that we know of copies of the petition and order showing that probate has been initiated. And then we have to publish with the local newspaper, we say a publication in circulation stating that somebody's passed away and we've opened up this probate process.
Now, is there going to be a court hearing?
Not unless there's a dispute.
Okay. Now, and then we this is always a big issue in Virginia is will the court require the personal representative to obtain a surety bond?
Well, the statute says they have to. And so, yes, but if somebody petitions the court to be the personal representative and forgets that piece, then it often doesn't come to light and it's not an issue with the court. And if the will says that the personal representative doesn't have to obtain a bond, then we don't need to.
You know, we typically see that in the wills, that they waive the idea of surety. Well, let's turn to, we're opening up a probate. We've got to figure out, you know, who's supposed to get all this stuff. So how do we go about, you know, why is it important to actually identify heirs at law and beneficiaries under the estate, under the will or no will?
Sure. So we need to be able to identify them to know that who we have to provide copies of the orders and notices to statutorily. They need an opportunity to contest the probate proceedings, or sometimes they're creditors and they need an opportunity to be able to file a creditor claim in the probate.
And so what is the best way that you found to locate beneficiaries and heirs at law?
Normally, the personal representative is a family member or close friend, and we see that they know the whereabouts and have addresses and are in contact with the beneficiaries. If for some reason we're unable to find someone, we'll use reasonable efforts to investigate their whereabouts. We will ask family and friends, we'll look on social media, we will put an ad in the newspaper, any way that we can think of to maybe contact them.
Now, if you cannot identify these folks through those various means, what can you do? I mean, are there any other resources you can turn to?
Yeah, so right now, there are lots of companies out there who specialize in finding these other parties of the will or the beneficiaries that we can't locate. So we can hire them, or sometimes attorneys subscribe to research tools where they might have additional means to contact somebody and find out where they're located or where they were last located.
Okay. Well, let's take a look, regardless of how the estate is probated, what are some of the important duties that a personal representative has?
Sure, and it's probably important that I mention that these duties are fiduciary duties, and so they need to make sure they're acting in a way that's in the best interest of the estate and the beneficiaries. So what that means is they'll need to open up a separate checking account for the estate and not commingle the funds with their own personal assets. They'll probably need to get an EIN number for the estate, so the last taxes for the decedent and any income that the estate makes during the course of probate can be filed with the IRS. They'll need to close credit cards, deal with creditors, provide notice to beneficiaries. It's a lot of work.
There is a bunch to be done, and so one of the things that comes to mind is the inventory. Cannot be waived. You have to file an inventory with the court. And I wanted to get into, how do you establish the values? And we had a conversation about that as we prepared for the show, about how you establish the values that you report on that inventory. Could you comment about that, please?
Sure. So Wyoming says that if there is a readily determined market for the value of an asset, that can be used. If there's not, then we have to hire professionals. So for example, if there's a vehicle, we know the mileage, the year, we can use Kelly Blue Book to assess the value of the vehicle. If there's real estate, we have to use either an appraiser or a real estate agent to give us a current market analysis. If there's a business, we have to get a full-blown appraiser by somebody who is qualified in that area to do it. So that's how the values are established for the inventory.
Okay, that's important. So apart from the inventory, apparently there is a need for at least one accounting for an estate, and that can be waived by the beneficiaries, I understand. But we don't want to dwell on that. Are there any notice requirements to be given to beneficiaries and creditors about inventories and accountings?
Yes, we have to provide the creditors and the beneficiaries that a final report has been filed, and if that accounting hasn't been waived, that's also been filed with the court to give them an opportunity to contest any issues.
Now, I understand from our conversation as well that the final report and accounting has to be, generally would be filed within 1 year, but if it goes beyond a year, then we may have to do an interim accounting. I want to also talk, though, is there any special probate considerations if real estate is probated?
Yes, so if the heirs are wanting to sell the real estate, then they actually need to obtain prior court approval for the authority to sell that real estate and then have it confirmed after it's sold.
Okay, so most sort of formal probates, how long do they typically take?
We easily see them taking 8 to 12 months if there aren't any issues.
Okay. All right, next topic I want to touch on, and we're working on a constrained time frame because there's so much information here. Let's talk about creditors. Is there a notice requirement to be given to known and unknown creditors, and what is that notice that we give them?
Sure. So yes, we have to give known creditors written notice about the probate. And for any unknown creditors, that's where we publish in the newspaper that somebody's passed away and we've opened up a probate.
And the purpose behind the notice is to give them a chance to make sure they can make their claims. Is that correct?
Correct.
So
Yes.
if we do all those things with either notice in writing or by publication, how long do they have in which to file their claim before they're cut off?
They have 90 days after the first date of publication. If they're an unknown creditor, if they're known and we've given them direct writings showing that the estate's been opened, then they have 90 days either after the first publication date or 30 days after we mailed them notice, whichever's later.
And the claims they want to file, those get filed with the court, is that right? The clerk of court?
Yes, in duplicate with the court.
And so then when the personal representative at that point then figures out whether they agree with it or they're going to negotiate or whether they're going to dispute it, and that may settle up quickly or otherwise may extend the estate.
Exactly.
Let's turn to, we've done all this stuff, we've taken care of our business at hand, and we're really ready to wrap the estate up. How do I go about wrapping up this estate?
Sure. So after the approval of the final report and accounting, then the personal representative distributes all of the assets and petitions the court for discharge of being the personal representative.
So when we file that petition, we give notices to the beneficiaries, is that true?
Yes, they receive notice of that final report ahead of time.
Now, how are fiduciary fees and attorney fees determined in Wyoming for the probate of an estate?
In Wyoming, that's set out by statute. And so both the attorney and the personal representative may receive 2% of the value of the estate upon distribution.
Okay. And then we talked about the fact that the lawyer can't really wear two hats. So if they're the fiduciary, they're not going to be the attorney or vice versa.
Correct.
Which I think is good policy. You've been probating estates for a number of years, not that many because you look very young, but I mean, let's just say, can you share with our viewers some of the lessons you learned over your years of probating Wyoming estates?
Sure. So Wyoming probate, I often tell my clients, is not as friendly as it is in other states. It's a very public process. It's expensive. It can take a long time. So if possible, they really should ensure that if their goal is to avoid probate, to meet with their estate planning professional to avoid probate. And they do that by getting legal advice at the outset, do some preventative family planning, create family harmony, and ensure that their assets are being distributed the way they want upon their death.
Family harmony is a great idea.
Yes.
It really is. So let's go now to getting your closing comments with some final words of advice, on steps that people should take, pitfalls to avoid in undertaking a probate in Wyoming. If you could share your thoughts, please.
Sure. So I think that it's important to know that having a law degree gives everybody the license to provide estate planning and probate services. But what you're looking for is an attorney who's experienced in this area, and someone, not maybe the local divorce attorney, but maybe somebody who has handled a lot of probates, because there's a lot of statutory guidelines. And so you want to make sure you are marshaling the assets appropriately and that you're preserving the estate in a way that doesn't cause any liability to you as the personal representative if you find yourself in that position. So really do preventative planning, meet with an estate planning professional on the front end, and I think a lot of those pitfalls will be avoided.
I think that's great advice, excellent advice, and especially given the circumstances of how estates are probated in Wyoming. I mean, on behalf of the Probate Nation, I want to thank you, Marty, for visiting with us and for sharing both an overview of Wyoming probate law, your advice as to what to do and not to do if probate is necessary, and the need for a Wyoming attorney to handle the details of your probate journey. Valuable information and really a great public service to our Probate Nation viewers. So thank you very much for taking the time to do so today.
It's my pleasure. Thank you for having me.
You're very welcome. Without a doubt, probate can be complicated and confusing, Marty has given you an excellent introduction to the Wyoming probate process, including steps to take, pitfalls to avoid, and the need for a Wyoming attorney to drive this probate. If you heed her advice, your Wyoming probate train ride should go smoothly. But I would be remiss if I did not emphasize that Wyoming courts will not allow a probate to be conducted pro se, meaning without an attorney. You need a Wyoming attorney to handle the Wyoming probate. The guidance of an experienced professional will help you avoid unnecessary work, delays in your probate journey, and additional fees and cost. This brings us to the conclusion of our show. I hope you found the show helpful. Replays of shows can be viewed on the Probate Nation website and our YouTube channel. On behalf of the Probate Nation, thank you for visiting with us.